Happy Wednesday. I want to thank everyone for joining in the Local First Empower Circle for our workshop series. Today we have Paloma Goggins, which is the owner of Nocturnal Legal. It's a boutique business law firm located in Scottsdale. And Paloma supports business operators, buyers, and sellers.
Giving this webinar today and to talk to you about all the legal documents that your business could have or need. And so I'll kind of guide you through this. And if there's any questions, I will have time at the end. So just write them down or have them in your head for when we complete the presentation. Am I good, Anita, to just kick it off?
I believe so. Hold on one second.
And we can wait a couple of minutes if you'd like to just wait for people to join as well.
Okay. I didn't know whether Alyssa?
Yes.
I don't see anyone in the room.
We have 4 attendees so far.
Okay.
Yep, so people are starting to arrive.
Okay. You think I should reintroduce Paloma?
Sure. Yep. I want to give it maybe 30 more seconds and then we can start. Yep.
Okay. Well, let me know when to start, Alyssa.
Sure, you got it.
Okay.
Thank you everyone for joining. It'll just be about 30 seconds to a minute here while we wait for some additional folks to join, and then we'll go ahead and kick it off. Alrighty, Anita, let's go ahead and get started. We're at 12:02.
Happy Wednesday. I want to thank everyone for joining in Local First's Empower Circle. And today we will have Paloma Goggins, which is the owner of Nocturnal Legal. It's a boutique business law firm located in Scottsdale, Arizona. Paloma supports business owners, buyers, and sellers. And we're so happy to have Paloma to be able to join us and share her expertise. Paloma, feel free to take it away. Thank you.
Thank you for the introduction, and I'm pleased to be giving this presentation today. So for today, we're going to be talking about a blueprint for your business, which is essentially navigating the legal documents that you already have in place or that you might need to have in place. So I will kick this off. So the agenda for the presentation is I'm going to tell you a little bit about myself, and then I'll talk a little bit about organizational documents that you would have typically when starting an entity and how important they are even for the maintenance of those documents throughout the lifetime of documents, which are anything related to the daily operations, and then protecting your IP. And then there will be time for questions at the end. So a little bit about me. I went to the University of Wisconsin-Madison for my undergraduate, and I went to Washington University in St. Louis for my law degree. I moved out here with my husband in the Valley about 3 years ago now. We are from Wisconsin originally, and all of our family is still out in the Midwest. One of the things that we love most about living in the Valley and Arizona generally is that we love to do outside hobbies. So I'm a big hiker. Actually, everybody told me how hard it was going to be, and I feel like I underestimated that hike. It was also raining for part of the hike, so that probably didn't help. But if you have a favorite hike, I'd always love to know what your hike is and kick off more hikes as I go. So jump right in on the organizational documents. So briefly, I just want to talk for a second about the different types of entities that you might have or that you might be thinking about starting. So
Paloma, it's Alyssa.
They're kind of 3 main buckets, and obviously
Paloma, there's a little bit of a digital drag with the video.
Something I can do to fix it?
I'm not sure if it's your connection or not.
Let I'm not sure if I can fix it. Let me close out some of the windows on my computer to see if that
Right.
speeds things up.
Thank you. Thank you.
Okay. Oh boy. I think I just closed out of my presentation. Please hold.
Nope, it's still there. It's still there. You're doing great.
Is it?
Yes.
I feel like I don't see it anymore, so I don't know. Hold on. Downloads. Okay. You were sharing screen. All right, so I think view full screen. Okay. All right, I have everything closed. Is this any better?
For now, it sounds better.
Yes, and now we see there you go. All right, let's continue and see if that works. And maybe the next step would be closing the video and speaking over the video.
Okay.
There
All
we
right.
go.
So okay, perfect. So three main types of entities that you might have, or you might be thinking about starting even as either a new business or a complementary business that's part of your overall entity structure. Typically, people fall into these three buckets. So one is a limited liability company, two is a corporation, and three is a partnership. I'll start with a partnership because it's the least popular. So each of these entities are all going to have their own unique organizational documents. And I'll get into that in more detail in the further slides. But on a high level, if you're ever thinking about adding another entity to your structure or changing your entity from an LLC to a corporation or starting a whole new business, this kind of gives you the lay of the land. So partnership is the least popular, right? Because it's more, I don't want to call it antiquated, but there's a general partnership and a limited partnership. And for flexibility purposes, most people opt for the LLC. It gives you greater control over how the entity is run and operated by its owners. And especially if you're just a single member or a single business owner, an LLC is super easy. Corporation is more structured. So there's annual filing requirements with the Arizona Corporation Commission. In most states, there's annual filing requirements. I will say Arizona is unique in that the LLC doesn't require annual filing requirements. So a lot of other states, if you ever started an LLC in another state as part of your entity structure, or you were expanding just like a corporation. So something to just keep in mind. But I always do tell people, if you are operating a business as a sole proprietor, as much as it might make sense because it's easy to, what could I say? It's easy to just have pass-through taxation. A single member LLC is still better from a limitation of liability standpoint. So it protects you more. So I'll hop to the next slide. So breaking these down further, with an LLC, you have the articles of organization, an operating agreement, and sometimes people will pull out the buy-sell portion, and I'll get into all of this, so don't worry about it being kind of high level at this point. Some people pull out the buy-sell into its own agreement, separate from the operating agreement. For a corporation, it's called articles of, two are always separate. You never have bylaws and shareholder agreement combined. And then finally, for the partnership, it's more, you still have a version of articles. It would be more of an articles of organization than an incorporation, but you have a partnership agreement. One thing to always keep in mind is that what you do for tax election purposes does not change the underlying structure of your entity. I actually get asked that a lot. People will have an LLC and they decide to do an S Corp election. They ask me, one, can I make the S Corp election? I tell them, no, that's your accountant's kind of role or area of expertise. And then two, just because you make an S Corp election with an LLC does not mean that you change the actual underlying corporate structure. But this does play an important role in the organizational documents itself. So I'll touch on that briefly when we get to the operating agreement side. Am I still okay on sound?
Yes, you're doing great. Thank you.
Okay. So to start off with, we're going to talk about the articles of organization or incorporation. I just want to see. Yeah. Okay. So we're going to talk about first just the articles. So in Arizona, your articles are, if you file online, your articles are generated by default unless you upload your own drafted articles. But you can draft them or amend them to include specific rights. So some things that people don't corporation, your articles can provide for additional rights and obligations beyond the operating agreement. And the operating agreement's on the next slide. I just wanted to make sure with the next slide because I'm going to talk about it kind of sequentially. So, but things that are always in your articles of organization or incorporation is your members or your shareholders, right? The people who own equity in your business. If it's an LLC, it'll have, if you have managing members as opposed to just managers, you'll be able to determine who's a manager and who's a member. Your principal address, who's your registered agent, and then keeping that updated as your entity evolves. So let's say you have an LLC, you have a business partner that you originally hired as an employee, and now they're such an integral part of your business that you want to add them as an actual owner of your business. But your ACC filing online looks like you're still the sole member. What you want to do is amend the articles of organization to properly reflect that ownership. This is important not just from a banking perspective in case you change banking information or you change banks, but also for the potential sale of your business at a future time. So sometimes people think, I do a lot of merger and acquisition work, which is just a fancy way of saying I help people buy and sell businesses quite frequently. So a lot of people think, oh, my business is just a small business. I'm never really thinking about exiting. Well, even a small business can still be sold potentially in the future at just in a price that makes more sense for what the assets are worth or what the book of business is worth. So I always tell people from a record keeping standpoint, having the articles of organization or incorporation maintained at all times is super critical. I'm going to flip quickly to the operating agreement. So in an LLC, you have either an LLC agreement or an operating agreement. They're one and the same. They're just called differently. So what an operating agreement does is it governs the day-to-day operations of your entity. It talks about how the ownership is held, what percentages each person has, whether it's member managed or manager managed. So if it's just member managed, it'll talk about the rights and obligations of members and how those members vote. If it's manager managed, it'll talk about how the managers make decisions on behalf of the entity. And most importantly, it'll decide how much power a manager has to make those decisions without first consulting with the members. And then other important provisions can include decision-making processes. So if it's just two members in an LLC, then you're going to want to have provisions that cover off instances where what if a universal vote is required? So everybody has to agree, but then you can't agree on the vote. So you have to have a provision that talks about what happens if just the two members can't agree. This applies in instances where every member must vote in accordance, but there's an even number, right? So there's no tiebreaker. So if you have three, you have a tiebreaker inherently built in because someone's going to vote one way or the other. So anytime you have an entity where voting is unanimously required in some instance, you'll want to have to include something that helps, we call it like a deadlock or a break tie. So another thing is that an operating agreement can encompass buy-sell language. So it's funny because each state kind of has its own unique culture. In Arizona, I've seen people come to me with their organizational documents that were drafted by, their original organizational attorney. So whether that's the state planning attorney that they had originally or a business attorney. And I've noticed that in Arizona, a lot of people have in Wisconsin, where I was practicing before moving to Arizona, it's actually very common to have everything all in one in the operating agreement. So I want to make sure, the buy sells on the next slide. Okay, so I don't want to get too far ahead, but essentially the operating agreement covers your day-to-day, how voting works, who can make decisions on behalf of the entity, how can it be dissolved, and then I always say the big D. So disability, divorce, and death. And those are all critical to what should happen if and when membership or who is a member changes. So then with the buy-sell agreement, what typically gets covered in the buy-sell is how members can transfer their ownership. Now, if this was incorporated into the operating agreement, you simply would just see that language built in. And that's how I like to. Running a business can be complicated, it can be messy, it can be busy. So having organizational documents all included in one place, I think makes it just easier for when you amend the document later to keep everything in one place. So going back to just the generic understanding of what a buy-sell or buy-sell language would have, it talks about who members can transfer their interest to, what should happen if a third party makes an offer, and then if it's not already included in the operating agreement, you might see some other things like the big D that we just talked about, or what other triggering events for transfer might occur. So one thing that people aren't very familiar with is tag along and drag along rights. So tag along is where there's multiple members in the entity, and if a third party offer comes in for just one member's interest. So let's say I have an LLC, I'm in it with Anita, she's got 40%, I have 60%, and someone makes an offer to me to buy the business. Tag along would allow Anita to join that transfer so she could be bought out as well. So she's not just left alone with the new owner potentially. Drag along, very similar concept, but instead I get made an offer for my 60% interest in my company, and I decide Anita is coming with because she's less than 50%, and I drag her into the sale of the business. So those are some key considerations that aren't always top of mind with people, but they can be important if the business grows to a state at which someone decides maybe they want out, and other members have to make critical decisions about whether they want to continue to be in the business. And then finally, redemption rights, that's really just about whether a company could at some point buy back or essentially claw back membership interest. It's not as common because a lot of people make investments in order to be a member in an LLC. But in some instances, you might have small, minuscule amounts of membership interest given to key employees. And if that employee were to do something wrong, like embezzle funds or commit a felony or do something really operating agreement that stipulates that if they do something very wrong or they quit and something goes wrong with the relationship, that the company has the right to claw back that interest so that they don't remain a member of the company after they're long gone for employment purposes. So I know I'm talking fast. I want to get through some of the slides. I promise there'll be time afterwards for questions. So switching over to the corporation, every corporation has bylaws, and if the things I'm talking to you about are like, whoa, I don't have these things, then something to think about is putting these in place, because they're super important. Even if you're a single member or a single shareholder, these are still critical aspects of helping you maintain good corporate governance, which is essentially just good housekeeping or good document keeping. So from a bylaws perspective, very similar to an operating agreement, it's going to talk about the operation of the corporation. So that transfer between members or outside of the company included in the bylaws, that is specific only to the day-to-day operations. So that's going to be covered in the shareholder agreement, which is on the next slide. But key things that go in the bylaws are general company information, board structure, so how many board members, how can they be elected, how can they be removed, can a board member resign, how are shareholder and board meetings held, when can they be called, are they annual, and then what are the powers of directors versus shareholders. So in some bylaws, you might decide the board of directors has more power or less power, and they'll defer to shareholder power in voting processes. So you can also add committees. So a board could have a subcommittee, and obviously this changes based on whether it's a for-profit or a nonprofit. You see a lot of committees in really large companies that are for-profit, but in nonprofits, you might have subcommittees of boards that are all specific to each function. So you might have one general board that makes really key decisions about the company, and the shareholders don't really play a huge role. And then their subcommittees might handle events, or they might handle giving, or some sort of aspect of that nonprofit day-to-day operation. And then finally, another key aspect of bylaws that's always included is dissolution. These are all high level, just kind of giving you an idea of what's in the document. Obviously, how you run the company and what's important to your company can also be included in these documents, in addition to any general provisions that are typically seen in bylaws or operating agreements. So talking about the shareholder agreement, this governs the relationship between shareholders. So it's very similar to what we talked about with the buy-sell agreement in an LLC. So if you have a corporation, this would cover things like the tag along and drag along, whether someone can share their transfer their shares outside the company with or without consent of the other shareholders, and then voting rights and the deadlock provision we talked about having very similar potential need when shareholder rights are being kind of divvied up and made different depending on whether the shares are Class A or Class B. So lots of different ways that you can structure bylaws and shareholder agreement to work together, but it's in shareholder and the corporation, then none of the relate back to the bylaws. Oh, one final thing before I leave this slide. Shareholder agreement and operating agreement can both include restricted activities. So one thing I see often is when people are adding potential employees as business partners as things progress, or maybe they add a sister, a friend, or someone who's a big business partner for them and their business, they might want to restrict certain activities. So they might want to say you can't compete with the business for a period of time after you leave as a member or a shareholder. You might have certain things about you can't solicit employees. So once you're no longer a member or a shareholder, you can't steal our employees, things like that. So as a business owner, some of that can be really protective if ownership in the business changes over time. Finally, the partnership agreement. I'm not going to waste too much of our time here because I know it's just not a very common entity to have, but a partnership agreement is very similar to an operating agreement and bylaws and shareholder agreement combined, in that it governs the operation of the business, but it also governs the relationship between partners. So it covers things very similar to an operating agreement in that it talks about the ownership structure, how the company is managed, how the partners make decisions, how interest could be transferred, deadlock if there's an even number, and then of course the big D's, disability, divorce, and death. So I want to flip away from organizational documents. So just keep in mind, if you have old organizational documents, it might be time to go back and refresh them, or just have a review of them to make sure that they align currently with your current ownership or your current operations. If you don't have them, I highly recommend getting those drafted because it covers all the bases, and especially if you have more than one business owner that has ownership in the company. So switching to employment-related agreements, there's a couple of different nuances here. A lot of people think, oh, when I hire, I'm just going to hire with one sweeping employment agreement. And it's a big mistake that I see often happen. And one of the issues is that an employment agreement is far more binding than the other options. So starting first with the independent contractor agreement, you would utilize this for a 1099 worker. So anybody who's not going to be a W-2, that you're not going to have direct control over the exact hours or maybe the exact time of project taking, and sort of having more flexibility. You see this often with people that are part-time or work remotely. It typically covers what's included in an NDA. So it would be a non-disparagement, which means you can't talk badly once you leave. Non-compete potentially if they're doing stuff that's highly specific and they could go and potentially recycle that or reuse it on their own. And then it would typically cover the scope of work. So I see some people use independent contractor agreement for work. I also see people use them as a kind of a one-up solution for when a scope of work or a limited project is being conducted. They might put those projects each in an exhibit. On the flip side, if someone is a W-2, you might say, well, if I'm not sending out an employment agreement, what do I send out? That would be an employment offer. So an employment agreement is far more binding. It typically includes a guaranteed time period for which they would be employed. And then because of that, and because you don't have the right to inherently just fire someone for no good reason, it typically includes severance. And notice can be longer. Doesn't mean you have to have just 2 weeks in an employment offer. But so employment agreement is like a very formal legal document, and an employment offer is more like a letter. So it's very casual. It just kind of types out on a very casual basis, what are the rules of employment? So what are the duties? What's the role? What benefits do you have on a basic level? What is your PTO potentially? And then everything else falls into an employee handbook typically. So what I see frequently is I see people entering into employment agreements when they should be entering into employment offers. If you have people on employment agreements and you want to get them on offers, I would suggest just putting together offers and having them re-sign so that you get them off the agreement and get a new agreement drafted. Alternatively, if you don't have an employee handbook and you have a bunch of very basic employment offers where it's maybe just an email and someone agreeing, or maybe just a very slapped together letter and it doesn't cover all the bases, like maybe it misses the language for at-will employment, that would be a place for you to maybe update or amend that employment offer and or get an employment book together where it talks about all the policies and ways that you might be able to terminate an employee if something isn't going right. So switching to commercial agreements, and we're making good time. I want to make sure I have 15 minutes at the end for all the different questions. So customer agreements are those that are facing your clients or customers. So I can't tell you how many times I speak with a client and they're using an invoice or a proposal or some form of agreement that's not a true legal agreement. And so what you can do to really reduce liability and to make your relationship more clear between you and your customers, your clients, is to have a more formal agreement put together. So when people ask me, well, what's the difference between sale of services versus sale of goods? Service agreement, master service agreement, professional services agreement, they all have different names because they all function the same, versus purchase and sale of goods or purchase agreement or something along those lines. So that's all very similar as well, but the name just changes and the nuances inside the agreement changes based on the scope of work. So one thing that people miss out on when they use proposals and invoices is that you don't reduce liability in the same capacity because you're missing the limitation of liability, ways that if somebody else does wrong to the other party, they can go back and be protected from that wrong. And then they also miss out on the option to have alternative dispute resolution, which avoids going to court. It leads people to go into either mediation or arbitration, which depending on the type of work that you're doing or the type of sale that you're doing, it might be more beneficial to have an alternative dispute resolution provision. And then finally, it allows you to potentially have liquidated damages. So good example is people that are in, let's just use like a service-based company that's doing landscaping work. So if somebody signs an invoice and it doesn't include all the terms and conditions associated with the work, and they start, maybe they get an initial deposit, but it really doesn't cover all of the work and all of the supplies. It's just a hold me over, tie me over, right? Then the client decides to pull the plug, they stop making payments. Well, if you some of that money that you had originally, like someone terminates an agreement early, you could have a provision that stipulates that they must pay you for terminating early or electing to no longer move forward with the services as planned. And that might make you more whole from what you originally purchased in advance of providing the services or for all the setup that you did. So I have a lot of software as a service companies as clients that like to have liquidated damages because they spend a ton of time and energy at the outset setting up their clients on their service or their software that isn't really incorporated into the initial cost, but they get paid it over time, right, as the contract continues. So liquidated damages sometimes helps them make whole if someone decides to terminate 6 months into the relationship. On the flip side, you have vendor agreements. So don't think of this as the agreement you have with your customers or your clients. but the agreements you have with your service providers, the people who you pay for the things that you need for day-to-day operations. And let me tell you, I cannot stress an online service or an online software is negotiable. Do I recommend that you go to Microsoft Office and try and negotiate that agreement? No. But of course, there are smaller businesses that you will work with that you could go in and potentially negotiate the terms, even if it shows up in your inbox as a DocuSign and it's already a PDF and all your information is already inserted, is 100% negotiable. So things that I always try and negotiate on behalf of my clients when they send me vendor agreements or service provider agreements is potentially the scope of services, because perhaps they've thought that they negotiated some sort of provision of services in exchange for X amount of money. And then the contract comes in and it doesn't match what they agreed upon verbally, how payment is made, and how payment can be late and not terminate the agreement or cause a breach. So I always like to give my clients the opportunity to cure if they're late on a payment, without having the contract just automatically terminate or cause liquidated damages to occur. How the contract can be terminated is hypercritical. I can't tell you how many times I work with businesses that have signed software related agreements and there's no way out. So there's no way to terminate the agreement whatsoever other than to just ride it out or pay a liquidated damages provision. So yes, I'm like advocating for liquidated damages for you as a business on the other side. But if you are the actual recipient of services, that's where we like to go to a different vendor or service provider. You don't want to pay. Sometimes the liquidated damages provision can be like 10, 20,000, depending on what you've signed up for. So it can be very hefty. And then finally, looking at your liability indemnification. If someone is going to be providing you services and they're taking your confidential information or your patient information or client information, whatever it is, if it's sensitive information and they're working with it or in it, maybe you want to be able to protect yourself for data breaches or their negligence when it comes to allowing people access to your information in a way that damages your business or leaks your trade secrets. So something to think about there. And then lease agreements are something that people obviously always inherently have to deal with. They are always written in favor of the landlord. Even if the lease agreement is very simply written, which most of them are not, and 50 pages, if not more, sometimes depending on the space that you're leasing, they can be exceptionally difficult to read. I think sometimes they read like dictionaries. I do think even though it's easier to just sign on the dotted line because you found a place that you like and you want to move into that space, I highly recommend sending your lease agreements, whether it's a renewal of your current space or a new space that you're moving to an attorney to make sure that you're not agreeing to things that are outside the bounds of what a landlord should make a commercial tenant pay. So things I always like to tell my clients that even if you don't send it to an attorney, things you should look at: renewal rates. So how much is the rent going up year over year? How long is the initial term for? And do they have the ability to just change terms without really your consent? What happens if your space is damaged by fire or casualty? Abatement, which is a fancy word for saying rent is just paused until the space is repaired or you can go back and operate your business. Some leases don't cover an option where if it's so damaged and you can't operate your business anymore that you just can get out of the lease. And that's 100% something you would want to have in there, because let's say a tenant next door lights their whole kitchen on fire, you're also a restaurant, and then you can't go in and operate your money elsewhere outside of your restaurant. And so at some point, after a certain number of days goes by without you being able to get back in the space and reopen your business, you should be able to get out of the lease and not have to pay rent. And then what are your rights individually? I reviewed a lease actually end of last year where it was for a retail space, and buried in all of the text, it said that they could just relocate the tenant whenever they wanted to a new space, or if they didn't have a space available, they could just terminate the lease. And it was a restaurant. And how can you just relocate a restaurant who has all this kitchen equipment, right? So those are the things that maybe the lease on its face looks really normal and completely agreeable, but there could be very like very challenging and very unfair provisions just buried inside somewhere, especially if it's a longer lease and you're not reading line by line. Finally, I want to talk about IP related agreements. So I think we're doing good. It's 12:35. So I'm going to wrap this up. Questions. So first and foremost, everybody who has a business where they're talking to another business or a third party or someone who they might be hiring and they're giving away very key information about your business that's not public knowledge should have an NDA. So I see this most frequently with people who they're starting a business that has a key idea that perhaps is something that could be stolen, or they're sharing client or customer lists with sales teams. And so an NDA can in some ways be wrapped into an independent contractor agreement because a lot of the language will be included. But if you're hiring someone as a W-2 and it's just an offer letter, not a full employment agreement, which would be more common as an executive hire, like a vice president, a CFO, a COO, or something like that. If you're just using an employment offer, which you should be in most cases, you'll want to have them sign an NDA as well. So it's not just business to business dealings, but it can also be business to employee. So things that an NDA always includes is scope of confidential information. So what does that information actually pertain to, or what does it include? Having an exemplary list of what is included typically is always nice as a baseline. What's the purpose of sharing the confidential information? So if it's an employee, I want to say for the purpose of collaborating to create a joint product or a joint offering or something like that. There's always an exception for when you have to legally disclose information through the court process. And then responsibilities when the purpose is complete. So typically, what I like to include in my NDAs is that people have to return or destroy the confidential information so it's no longer in their possession. And then depending on your circumstances, you might have covenants like what we talked about earlier, where you have non-solicitation where someone can't steal your employees. You might have non-disparagement if it's an employee that you're having signed the NDA because you don't want them to talk badly about you after they're fired. Non-circumvention is when you are making introductions. So this is when you're like trying to land big business deals with maybe larger operations and you're pulling in a complementary business. You see this when people are doing, and non-circumvention helps to prevent them from swooping in, stealing that opportunity away from you and using someone else in your place. And then finally, one-way versus two-way. So a one-way NDA is where someone is getting your confidential information, but you have no obligation back because you're not getting theirs in return. Two-way is where both parties are sharing confidential information back and forth. And so both have obligations related to non-disclosure and protection of confidential information. A licensing agreement is where if someone has intellectual property, a trade name, or any other type of what I consider protectionable information, and they're going to give it to a third party to use or use someone else's IP. So this is very common in franchise arrangements. So if you're getting into a franchise relationship, or maybe you want to start a franchise and you want to be able to take your word mark and allow another business to use it, then you would need a licensing agreement. And this allows you to say, look, here is the scope of how you can use this word mark. So a good example of like a franchise that everybody knows is Culver's in town. Culver's is way bigger in Wisconsin, but I'll just use it for this purposes. So like Culver's has other people owning and operating Culver's across the United States. They would have a licensing agreement with each of their franchisees to use the word Culver's for purposes of operating a Culver's in other states. So you're also going to have the purpose of the use, which in this instance, in this example, would be the operation of a Culver's restaurant. It will have restrictions. So oftentimes when I'm working with clients that are either looking to license out their information or get a license from someone else to use information in their own branding or their own products, is you're going to have restrictions on use. So that scope of use is important for restricting people from using it in a way that maybe reflects poorly on the brand. And then retained ownership. 100% the most important part of a licensing agreement is allowing someone to use something, but not own it outright. So being able to include language in there that stipulates, I don't care what I license to you, but this is still mine. And on the flip side, obviously, you're going to have that protection for, if it was a franchisor or a licensor, you're going to have that protection for them, which shows that they retain their ownership. So one final thing on the licensing agreement, provisions addressing that it may be included in a customer agreement or independent contractor agreement. Yes, you can have this piecemeal included in certain different types. So NDA and licensing agreement and any secrets can always be incorporated into other types of agreements, even vendor agreements, commercial agreements with your customers, employment agreements, independent contractor agreements. So just because we're looking at them separately in this context doesn't mean we can't include pertinent information in other agreements that are related to the operation of your business. So I want, in the 5 minutes I have left before we're going to open up for questions, I want to just do a recap of everything we've talked about. I'm going to take a sip of my water because I feel like I've been giving everyone the massive download. So starting at the top, we had organizational documents, which encompasses your articles of incorporation or organization, depending on the type of entity that you have. And then if you're an LLC, you have an operating agreement and sometimes a buy-sell agreement, or they can be combined into one. And all of that helps to outline the membership interest, the structure of how the company is operating, and then how the members play well together along with managers if it's manager managed. If you have a corporation, you have articles of incorporation, your bylaws, and your shareholder agreement, very similar to an LLC. It helps bring everything together. So it kind of outlines the rules for how the company operates on a daily basis, how the board of directors makes decisions, how meetings are held, how shareholders vote, and then how shareholders can work together or not together, depending on how you want the shareholder agreement to work. Employment related agreements. So you have independent contract agreements for 1099s, which is super critical for people who are on an ad hoc basis and you're not hiring them as W-2s. If you're hiring someone as a W-2, it would be an employment offer. And then if you're hiring someone as a W-2 and they're going to hold an executive role, that would be an employment agreement. Commercial agreements are those that are related to the day-to-day operation of your business. So if you're selling services, you'll want a service agreement instead of an invoice or a proposal. If you're selling goods, you'll want a purchase or sale agreement, depending on how you want to name it. If you have both, you can create two separate agreements or a combination of two. You inherently sign vendor agreements on a regular basis with all of the service providers that give you services. On a much smaller level, you can think about people who provide you with marketing services, website services, graphic design services, people who maybe are helping you with accounting or bookkeeping. So it doesn't always have to be Microsoft Office or Zoom, right? Even though we know we're agreeing to these massive corporate terms of service, it might be more local people who you've hired to help you. And then finally, IP related agreements. So anytime that you're going to share confidential information or trade secrets, which by the way, trade secrets they do include client lists. So people think of trade secrets as like the ingredients in ketchup, but trade secrets do encompass client lists or lead lists. So if you do have employees that are gaining access to your leads list or client list, having an NDA in place is super critical so that when they leave, they can't just like steal the list and take it with them or use it in a new role. And then finally, if you're working as a franchisor, so someone who's allowing other people to start businesses like your own, or you're entering wordmark or some sort of unique intellectual property that you would like to incorporate in your business or the sale of your goods, you will always find that a licensing agreement is tied to that. And that licensing agreement is, out of all the documents we talked about today, is the most bespoke in that it's very highly tied to what is specific to your arrangement. And so people always ask me, oh, what does it typically include? Well, of course, it includes the license itself, restrictions on use, and how you can use it in the future. But there are many different ways that a licensing agreement can be made more complex or less complex, depending on the situation. And so I always caution people, don't pull things off the internet. I know it's a temptation. You're doing yourself a disservice because it doesn't include things specific to your situation. That goes for all documents that you can have drafted by an attorney. I know legal sometimes is viewed as a cost center, but I can tell you from my own personal experience, having people send me documents they got off of LegalZoom or Rocket Lawyer, or even off the internet that they modified themselves, 100% of the time, they don't include the right language relevant to their specific position, or it doesn't include key language that limits liability. So I always advise people, please, 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 even in a limited scope opportunity, talk to a lawyer. I have talked enough. I will open it up for questions.
Great job, Paloma. Thank you very much. I think this might go back to the beginning of your presentation, but Shelby asks, is this necessary to have when there is just one single owner or only when there are multiple owners? And that might be in the entity type.
Yes. So one reason to have either an operating agreement or bylaws when you're a single person and there's no other owners of your business is that, and I'll give you a very specific case use. So I knew a client who passed away suddenly, the client's the daughter. So the daughter came to me, the father had passed away suddenly. He was owning a very large business. He didn't have an operating agreement. He also didn't have a will. So the whole company continued to operate with no person at the helm. So the operating agreement, let's just use that as an example, not knowing whether you have an LLC, the operating agreement allows you to name someone to step in and continue operating your business or wind up your business so that it dissolves upon your death or disability. And if you don't have that in place, then there's a really, really stringent, kind of confusing legal process that happens once you're disabled or once you pass away to allow someone to come in and do that without an operating agreement.
Thank you. Shelby, let me know if there's any follow-up to that in the chat. Next is from Alex. Alex shares, my challenge is that I have filed all of my business paperwork myself. We are a partner LLC, and I have really no clue if I filed correctly or if I'm missing things. What's the best way to get this reviewed or audited? And as we grow, I feel like this is going to be extremely important. She said
Absolutely.
she filed everything herself online.
100% agree that as you grow, obviously it becomes more and more important to have your organizational documents all squared away. So one thing that I offer for my clients, and obviously you don't have to work with me, you can work with whoever is, like if you have someone currently as a lawyer, but like how I handle things is, if someone comes to me and they're a little bit cost conscious because they're still growing and they're bootstrapping their business, I tell them, look, we can do the full blown, let's review everything. And I give you a summary of all the areas, or we can do piecemeal where you're like, hey, I think this is the most critical. Like, let's say you'll have an operating agreement that you just got off of LegalZoom and you want me to just take a look at it and give you some thoughts. That's more limited scope, so it controls your costs. Or if you're like, hey, we've grown to a point where I just need someone to come in with expertise and make everything more legitimate. I also have clients that just hand me everything that they have. We have a follow-up call where I tell you all the things I'm going to do, and they just let me go in and make all of the changes. Now, obviously, this has to be done in tandem with you and your other owners of the business because my changes are critical related to how the company operates. But I always want people to feel comfortable. You don't have to just like let me loose on your documents and you don't know what's going to be the end cost in terms of how much time is spent. I'm happy to have more limited reviews so that we do things step locked so that you understand and feel comfortable as we go through the process.
Thank you. Alex also asks, so do you recommend doing an NDA for employees and contractors? I have a cleaning business and plan on having that included to protect customers' privacy as well.
Yes. So if you are doing the 1099, it can be a lot of that language can be incorporated into the independent contractor agreement. If you don't want to have it incorporated, obviously you can have them sign the independent contractor agreement and the NDA separately. But one thing that's important if you do keep them separate is to make proper reference so that the independent contractor incorporates the NDA as part of the full agreement. Otherwise, sometimes the two are a little bit disconnected and rights and obligations might not flow from one to the other. With the offer for W-2, 100% have them sign a separate NDA and then make the proper reference in the employment offer to make sure the two are connected.
Great, and I believe that concludes our questions. Was there anything else from the attendees today that you wanted to ask in the chat? All right. Thank you so much, Paloma. We really appreciate the expertise that you shared today. Anita, was there anything else that you wanted to add? Oh, we'll have to take you off mute here. There we go.
Yeah. No, I just wanted to thank Paloma for just offering her expertise and just being able to, to share the importance of those documents. I know just being on the ESC team, which is the entrepreneur support team, just assisting businesses with just areas where they, maybe if they can't find their articles of incorporation, or maybe if they can't find their the filing in terms of the structure of their business. Those documents are very important when you go and open up an account, or say for instance if you need to add a beneficiary to your account. Those documents are so important. So I definitely wanted to thank you. I also asked Paloma if you could identify the, I don't know, I believe it may be 7 points to determine whether if a person is an employee or independent contractor, because I know as a small business, being a small business, sometimes that people think that they could take the easy way out by just hiring a 1099, which is a independent contractor, as opposed to being an employee, thinking that they are getting away with not paying the employment tax. But if you could at least highlight those, because there is a huge difference. But it's a very thin line to determine whether if someone is an employee or an independent contractor. Hello?
And great question, by the way, because this comes up a lot.
Okay.
So if someone is going to be working for you in a limited capacity or not on a full-time basis, even though you're doing a 1099. So a good example is if someone is helping out, doing things that are kind of not your core things that you offer to clients or customers, that's a really easy 1099, right? If you hire someone to work on your website or to write blog posts and you're a cleaning company, for example, that's an easy 1099. Where it gets a little more complicated is when you're hiring someone who's maybe working part-time and you have full control over that person, you start getting in this gray area. So I always tell people it's more of a control test. So in California, they have this thing called the ABC test, where if someone is bringing all of their own technology, so a good example is if I was to hire someone to come in and provide secretarial services, then they're bringing their own laptop. And if I'm giving them assignments and they complete them kind of at their will, I'm not saying, hey, you have to be at your desk at 8 a.m. until 5 p.m. They work for other people. Then that's a really good, easy example of another way that a 1099 works. Now, have I seen other clients where they hire someone on a 1099 and then they're working only for that company? They have no other business, they have no other jobs, no other side hustles. It's just that one company. That's a problem. And two, if you're hiring independent contractors remotely, which in today's age is fairly common, right? California has new laws in place that make hiring California residents or people who are domiciled in California 99 is practically impossible. So you would have to have someone from California be doing something totally unique and not something that you could do yourself in order to not run afoul of the California rules related to independent contractors. It's a recent law change in the past couple of years. I don't remember the exact date, but essentially it's become very confusing for companies that hire outside of the state of Arizona into California because California is so close. It's very common. And I would say anytime that you're going to hire someone out of California, talk with a lawyer to make sure that you are less in the gray area or definitely out of the red area, right? When you're hiring, and if possible, potentially you might have to hire them as a W-2. That is usually my recommendation, unless you're hiring them to do something very unique. The California website actually uses an construction company that does general contracting, and they hire an independent contractor as a 1099 to do like very specific work to install an elevator, which they don't do, and that was fine. So you can't, I think the other example on the website is you can't hire someone if you're knitting products and selling them on Etsy, you can't hire someone to knit your patterns and have them be a 1099. They would have to be W-2. So hopefully that kind of helps give some examples there.
Thank you.
All right. Thank you so much, Paloma. And as I shared before, we will be posting this on the local learning lab within the week, and we'll make sure to send out that information. And also Paloma's information is in our Business Coalition member directory, and I'll make sure to send that to everyone as well so they can ask Paloma some follow-up questions. Thank you very much for your time today, and we'll see you next month. Thank you, everyone.